This is Dr. David Schein, and welcome to Business Law 101. Now, you can see the significance of this first bullet. The loss will be borne by the party who has breached the contract. In one case, the buyer rightfully revokes acceptance. The risk of loss is back on the seller. Buyer repudiates the sale. Seller can impose the risk of loss on the buyer. So basically, the idea here is assigning risk of loss based on the free on board, the original agreement, but then if someone breaches the agreement, there's going to be a little bit more leeway there. So keep in mind that with regard to risk of loss, generally speaking, and again, I have a client that will only ship from its dock, does not have its own trucks. Everything is done by common carriers or by proprietary trucks from the purchasing side. But basically, you have a situation where there is a free on board the shipping point, then the risk of loss for the whole time period after that is going to be on the buyer, because the buyer is supposed to be coming to the seller's point of location. In the free on board destination, risk of loss does not pass the buyer until the goods arrive at the destination and are available for the buyer for delivery. So this is a very important distinction between free on board shipping, free on board destination. Now remember, in a contract, you can negotiate this term. You can say, well, we're going to pick it up or send our common carrier to pick it up at your dock, but we want you to keep it insured till it gets to our remote dock. So we'll see how that goes. And then under bailments, the title to the buyer, the risk of loss passes to the buyer. This is Dr. David D. Schein for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.